Great pleasure for me to accept an invitation from Freedom from Torture. From the onset of my mandate 5 years ago, I have counted on the support of Freedom from Torture in many different ways, and I continue to do so, and I know that my successor, a year from now, whoever that may be, will be able to count on the very creative and very professional expertise of all members of Freedom from Torture. And that's, for that reason, it's very important for me to be here today, and it's a great pleasure to accept your invitation. All states have an international legal obligation to take effective legislative, administrative, judicial, and other measures to prevent torture. However, in recent years, there is a real sense that states have taken a step backwards on enforcing these international principles. The practice of torture is still used in many states, and in some states it is a widespread practice. There are a number of factors behind this regression. Namely, there is a generalized sense, fueled by popular culture, that torture is inevitable, that someone has to do it, that it may be ugly, but it produces results, and therefore we must tolerate it, or at least look the other way, because it makes us feel safe. This is based on a false picture of how torture actually happens and ignores the steep price societies pay for engaging in torture. In this context, some states have attempted to dilute cardinal principles necessary to prevent and suppress torture and ill treatment, or have become complicit in acts of torture by other states under the rubric of fighting the so-called war on terror in the aftermath of September 11, 2001. Since then, there has been a rise in the use of torture and ill treatment and an increase in the practice of indefinite detention in the name of national security and counterterrorism, amounting to a deliberate undermining of the absolute prohibition of torture. The torture ban has been further eroded because national legal frameworks are deficient and do not properly codify torture as a crime with appropriate sanction, nor do they establish essential procedural safeguards to prevent its occurrence, to effectively investigate it, and to bring perpetrators to justice. In that scenario, a culture of impunity evolves. The instability this creates cannot be contained within national borders and thus impacts entire regions. The most recent factor for the backsliding on the torture ban is the security-heavy response to the worldwide upsurge in irregular migration and the perceived threat posed by the flow of migrants and refugees. It is vital that states ensure that people are individually assessed and identified, especially on their need for protection from persecution. This identification is essential to avoid exposing them to further trauma, ill treatment, or to being forcibly returned, to prevent, as far as possible, irreversible physical and psychological harm. The prohibition against torture and other cruel, inhuman, or degrading treatment or punishment enjoys the enhanced status of a jus cogens or peremptory norm of general international law and requires states not merely to refrain from authorizing or conniving at torture, but also to suppress, prevent, and discourage such practices. States have not only the obligation to respect, but to ensure respect for the absolute prohibition against torture. The existing international legal framework provides a broad range of norms and standards with an ultimate aim to prevent acts of torture and ill treatment. Some preventive obligations are explicitly listed in the Convention Against Torture, such as the prohibitions of refoulement, the prohibition of admitting evidence extracted by torture in any proceedings, the obligation to provide education and training to law enforcement and other personnel, to systematically review interrogation methods and conditions of detention, to investigate ex officio all suspected acts of torture, and the obligation to prosecute suspected torturers. In addition, an umbrella clause in the Convention Against Torture requires states parties also to take other effective measures aimed at preventing torture and other ill treatment. For that reason, states must take effective preventive measures, including by good faith interpretation of the existing provisions, to eradicate torture and ill treatment. My upcoming report to the General Assembly, which I will present in 3 weeks in New York, focuses on the extraterritorial application of the prohibition of torture and ill treatment and states' obligations under international law. States must take effective measures to prevent acts of torture by their agents in any territory under its jurisdiction. In General Comment Number 2, the Committee of the Convention Against Torture established that the term any territory under its jurisdiction includes, and I quote here, all areas where the state party exercises, directly or indirectly, in whole or in part, de jure or de facto, effective control, end quote. Extraterritorial application of the Convention Against Torture is key to the prohibition of torture. An overly narrow reading of the references to jurisdiction in the Convention, as the U.S. attempted in the early years after 9/11, leads to an interpretation of the treaty that is contrary to its object and purpose. For that reason, in its latest periodic report to the Committee Against Torture in November of 2014, the United States government actually returned to its commitment to apply the Convention to actions of United States agents wherever these actions are committed. The fundamental principle of universality must be upheld so as not to undermine the absolute prohibition on torture and cruel, inhuman, or degrading treatment or punishment. There are risks that the absolute prohibition and protections for torture survivors may be watered down if the Human Rights Act is replaced in the United Kingdom with a British Bill of Rights. What that British Bill of Rights will eventually provide for is obviously still to be decided. In a democratic society, a robust debate will ensure and must ensure whatever reform is implemented does not constitute a regression. Although some clauses in the Convention Against Torture and in the International Covenant on Civil and Political Rights contain jurisdictional limitations, it is clear that the obligation to take measures to prevent acts of torture or other ill treatment are not limited in that fashion. The obligation to prevent torture includes actions that the state must take in its own jurisdiction to prevent torture or other ill treatment in other jurisdictions. As I have explored in my Human Rights Council report that I presented in March of 2014, the fact that torture or other ill treatment would occur outside the territory of the state in question and not under the direct control of its agents does not relieve the state from responsibility for its own actions that effectively contribute to torture. There are assaults on the principle of universality, for instance, in suggestions to restrict access to certain human rights based on nationality or immigration status. All persons under a state's jurisdiction need to be treated in accordance with accepted international standards and afforded the same protection against violations of the Convention Against Torture, regardless of how or when they arrived in a country or how they came to be under that state's effective control. Universality is a fundamental principle of human rights, and there would be a very grave international implications if a state makes human rights contingent on citizenship or immigration status. Customary international law, as codified in the Convention Against Torture and the Optional Protocol, contains a broad range of very specific positive state obligations aimed at preventing and combating torture. I have identified 10 procedural safeguards which, if adequately implemented by states, could prevent further backsliding on the torture ban. 1, the abolition of secret detention. 2, the abolition of, or tight regulation at least, and control of incommunicado detention. 3rd, the proper registration of every detainee from the moment of arrest or apprehension. 4th, the prompt access to legal counsel from the moment of deprivation of liberty, as well as access to relatives. 5th, the video or audio recording of all interrogations. 6th, the prompt access to an independent judge with powers to rule on the legality of arrest and the conditions of detention. 7, the strict respect for the presumption of innocence. 8, the prompt and independent medical examination of all detainees. 9, the prompt, impartial, and effective investigation of all allegations or suspicions of torture ex officio. And 10, the effective training of all officials involved in the custody, interrogation, and medical care of detainees. The degree to which these safeguards are observed or violated in other countries, the countries from where the migrants come, should be considered in the receiving state in making determinations about their status or about their preservation from return. I take this opportunity to highlight the recent work of the Working Group on Arbitrary Detention, which presented what they call the UN Basic Principles and Guidelines on Remedies and Procedures on the right of anyone deprived of liberty by arrest or detention to bring proceedings before a court. End of the long quote title. The working group presented this document before the Human Rights Council session this month. This new protection tool compiles and complements existing norms, standards, and jurisprudence, and is an essential contribution to the protection of all persons against arbitrary detention, including secret detention, prolonged incommunicado detention, enforced disappearances, and torture. Last year, my interim report to the General Assembly examined the exclusionary rule and the use of torture-tainted information. I identified state practices regarding this matter and elaborated on the rationale and scope of the exclusionary rule in relation to formal proceedings and on the use of information likely obtained by torture or other ill treatment by executive agencies, not in any proceedings, as the Convention says, but in collecting, sharing, and receiving such information and intelligence between states in the course of intelligence gathering or covert operations. Since the prohibition against torture and other ill treatment is absolute and non-derogable, under any circumstances, states have a duty to prevent torture. The exclusionary rule must therefore also be absolute, including in respect of national security. Since the inception of the war on terror, executive agencies have been under extreme pressure to obtain information to protect their citizens. Many states refuse to subject the work of their intelligence and security agencies to scrutiny or international oversight. Similarly, domestic courts follow this lead, and under doctrines like state secrets, act of state, or sovereign immunity, they reject motions to submit these executive practices to judicial review, even when the issue is the absolute prohibition of torture. I called on states to refrain from creating a market for the fruits of illegal and abhorrent interrogation practices by collecting, sharing, or receiving information obtained by torture or other cruel, inhuman, or degrading treatment or punishment. It is not sufficient to ensure that the judicial process is free from the taint of torture. Torture must also not be encouraged, condoned, or acquiesced in through all manifestations of public power, and not just in the judicial process. A recent Surveillance Commissioner's report proposes adopting in the UK a consolidated guidance that could water down the safeguards that agencies and the Ministry of Defense are supposed to have in place while putting questions to detainees who are in states where it is known that authorities engage in torture. Interrogating while someone else tortures is a form of aiding and abetting the crime. And it certainly violates the overall obligation to prevent torture. The standards of the exclusionary rule should be interpreted in good faith and applied by way of analogy to executive actions that purposely and objectively promote torture by taking advantage of its results, including the collection, sharing, or receiving intelligence obtained by torture or other ill treatment, even if not used in proceedings narrowly defined. Torture-tainted information, even when not intended to be used in court proceedings, must be disregarded in the same way that a court would treat evidence obtained by torture or other ill treatment. Judges and prosecutors must routinely ask persons arriving from police custody how they have been treated and to order an independent medical examination in accordance with the Istanbul Protocol if they suspect that detainees have been subjected to ill treatment. They must also initiate an ex officio investigation if there are reasonable grounds to believe that a confession was obtained through torture or ill treatment. Similarly, authorities controlling ports of entry and border crossings and those who process irregular migrants or refugees should routinely ask persons how they have been treated and order an independent medical examination in accordance with the Istanbul Protocol if they suspect that individuals have been subjected to torture or ill treatment. If the aim of the exclusionary rule is to discourage torture, we must apply it not only when the victim succeeds in proving torture, but in all cases in which safeguards against mistreatment have been violated, as in arrest without probable cause or arrest and searches without warrant. Similarly, evidence that must be ruled inadmissible should not be restricted to the confession or statement directly obtained under torture, but to all other means of evidence to which the torture has led, even if regular procedures were later respected. Also, statements obtained through the torture of other persons and or by other agents must also be excluded from any proceeding and from any other use, because the purpose of the exclusionary rule is to discourage torture in all instances. To this end, a strict adherence to this most fundamental of rules is essential. The exclusionary rule should not only apply to judicial and administrative proceedings, but must apply to intelligence gathering and to operational decisions by the executive branch and its agencies. I have called attention to the serious concern raised by the tendency to use information gathered in violation of the prohibition on torture for purposes other than criminal prosecution. The objective of the exclusionary rule, as I said, is to discourage the use of abject methods of interrogation. If we leave open the possibility of other uses for that information, we are offering a powerful incentive to the torturer. An important obligation under the overarching aim of preventing torture and other ill treatment is the customary non-refoulement provision in Article 3 of the Convention Against Torture, which clearly states that states cannot expel, extradite, or return a person to a place where he or she could be in danger of being subjected to torture, even outside the territory and control of a state. In order to satisfy this obligation, states must also provide an effective remedy against the decision to transfer the detainee, which means that the decision needs to be known and subject to judicial scrutiny. The non-refoulement obligation is a specific manifestation of a more general principle that states must ensure that their actions do not lead to a risk of torture anywhere in the world. There is a clear negative obligation not to contribute to a risk of torture. Because of the importance of this rule, diplomatic assurances do not release states from their non-refoulement obligations, nor are they an appropriate way to prevent torture. Indeed, diplomatic assurances are unreliable and cannot be considered an effective safeguard against torture and ill treatment, particularly in states where there are reasonable grounds to believe that a person would face the danger of being subjected to torture or ill treatment. Diplomatic assurances are an attempt to circumvent the absolute prohibition of torture and non-refoulement. The Committee Against Torture, the Human Rights Committee, and the European Court of Human Rights have all stressed the absolute nature of the non-refoulement provision, a prohibition that does not depend on the guilt or innocence of the person who risks being tortured if deported or extradited to certain places. Those bodies have stressed that diplomatic assurances do not relieve the sending state from its due diligence to ensure that torture does not follow. The significance of the principle of non-refoulement in the Convention Against Torture is that it applies to all, even people who may not qualify as refugees or asylum seekers, as opposed to the non-refoulement provision in refugee law. States must separately assess the risk of torture and refrain from extraditing or deporting anyone to a place where he or she would be at risk of torture. There should not be a threshold before someone can claim violation of the ban on torture and CIDT and cruel, inhuman, and degrading treatment in the court of a receiving country by raising the bar on the burden of proof. There must be the burden of proof that an immigrant must meet to apply for protection against removal. There must be no loosening of standards, such as judicial guidances, because they could introduce an evidentiary threshold that could bear on the meaning given to cruel, inhuman, and degrading treatment. For the purposes of removal, there is a proposal to replace Article 3 of the European Convention on Human Rights with Article 3 of the United Nations Convention Against Torture. This seems to be intended to, A, remove cruel, inhuman, and degrading treatment from the ambit of this protection. So if someone might be subjected to cruel, inhuman, and degrading treatment but not torture, removal would be okay. And B, to have a more restrictive approach to the question of state or non-state agent involvement in torture, because a torture definition requires a state agent, and this might mean that somebody could be returned to a territory governed by the Islamic State, for example, because it's not a state. I understand there is also a suggestion to remove the ability of applicants to rely on the argument that removal would violate fair trial rights, where the trial abroad would be based on torture-tainted evidence. It is also a matter of deep concern that the United Kingdom government is seriously considering a decision to remove the right of individual petition to the European Court of Human Rights as a means to, and I'm quoting here, break the formal link between British courts and the European Court of Human Rights and make the UK Supreme Court the ultimate arbiter of human rights matters in the UK. End of quote. The right of petition to international organs of protection is a fundamental feature in the architecture of international human rights, and it would be by itself a serious setback to the progressive development of protections against abuse everywhere. In the case of torture, in addition, it would be deplorable if the United Kingdom wrote itself off from international scrutiny, especially since the United Kingdom does not accept the right of individual petition before the Committee Against Torture. The Convention Against Torture initiative was launched, CTI by its acronym, was launched in 2014 to mark 30 years since the adoption of the Convention. It aims to help all states to achieve universal ratification and to put the Convention into concrete practice. 38 member states of the United Nations have still not ratified the Convention Against Torture. Of the 157 states that have, many still face challenges of living up to their commitments regarding implementation, which means many states are at risk of backsliding on the torture ban. Regular and unannounced inspections of places of detention is an effective preventive measure against torture and ill treatment. It ensures the adequate implementation of safeguards against torture, creates a strong deterrent effect, and provides a means to generate timely and adequate responses to allegations of torture and ill treatment by law enforcement officials through a process of monitoring, reporting, and correction. In this context, it is important, therefore, for states to adopt the optional protocol to the Convention Against Torture that creates such a system of prevention of torture, but also important for states to adopt the revised standard minimum rules for the treatment of prisoners that is going to be known as the Mandela Rules and that are proposed in the agenda of the General Assembly for later this year. The work of forensic scientists is germane to the efforts to address impunity for acts of torture. Forensic expertise ensures that torture traumas, whether visible or invisible, physical or mental, are scrupulously documented before they disappear. Similarly, the corroborative effect of this professional opinion and its role in assessing the overall credibility of alleged victims provide a stronger evidentiary basis for prosecution and enhances the possibility to receive immediate as well as longer-term medical and other assistance and other forms of redress and rehabilitation and reparation. Medical records can overcome the loss of objective physical evidence with which survivors of torture are so commonly confronted, given that torture mostly takes place without witnesses. During fact-finding missions, I have called upon the authorities to ensure timely forensic examination of persons alleging ill treatment and guarantees that the medical staff in places of detention are independent from the organs of criminal justice, including corrections, as well as prosecutorial and law enforcement bodies. States must also provide training for forensic services in the medical investigation of torture and other ill treatment. Forensic science also has another use. It provides a much sounder and more effective way to investigate crime and successfully prosecute offenders, as scientific methods are a far more effective way to obtain accurate convictions and reduce criminality than the brutality of interrogation under torture. Science-based, independent forensic expertise is also crucial to an objective determination of the claims made by asylum seekers and migrants that must not be returned to a place where they will be at risk of torture. In December of 2014, I welcomed the release of the Executive Summary and Conclusions of the United States Senate Select Committee on Intelligence on CIA interrogation practices. The report contributes to fulfilling the obligations of the United States with respect to the truth and is an important first step towards implementing other obligations under the Convention Against Torture, namely to combat impunity and ensure accountability by investigating and prosecuting those responsible. The serious abuses detailed in the report constitute violations of fundamental human rights for which the perpetrators must be prosecuted and punished in accordance with international law. The U.S. government's failure to uphold its international obligation to investigate, prosecute, and punish is inviting other states to follow this example of impunity. It provides abusive regimes with a ready-made excuse for rejecting the international community's concerns about their own records of torture. As long as those responsible for torture evade accountability, would-be torturers will believe that they can too. Early in my tenure as the Special Rapporteur, I was encouraged by the announcement that the United Kingdom would launch a commission of inquiry into the role of United Kingdom agents in secret detention and abusive interrogation in the so-called global war on terror. As you know, the Gibson Commission of Inquiry was later shelved, presumably to allow criminal investigations and prosecutions to proceed without interference. The UK government has still not delivered a proper truth-telling or criminal accountability process to get to the bottom of allegations of complicity in torture and extraordinary rendition in the context of the response to 9/11. I am concerned that the current investigation by the Intelligence and Security Committee is structurally unable to discharge the United Kingdom's obligations to deliver an independent, effective, thorough, and impartial investigation into these serious allegations. There are serious questions regarding both the composition of the committee and its mandate, especially its very restrictive mandate. The report of the Intelligence and Security Committee will hopefully, however, recommend a new judicial inquiry. My comments at the time of the Gibson inquiry are still relevant today. Based on my experience, I said at the time that, and I quote myself, the only way to deal with the cancer of torture is to fully root it out with a wide-ranging, independent, and fully public inquiry, end quote. When used properly, a commission of inquiry can be a powerful tool to complement other investigative mechanisms in ensuring accountability of state actors and institutions and compliance with international human rights law. It also provides unique opportunities for a deeper understanding of the underlying context in which violations are committed, a review of governmental policies, practices, and institutional shortcomings, and truth-telling. My report on commissions of inquiry to the Human Rights Council in 2012 highlighted the integral role of commissions of inquiry in providing impetus to and eventually facilitating the formal investigation of torture and other ill treatment, and paving the way to effective and fair prosecutions which states are obligated to undertake. There are many other states that require the world's attention, most notably and urgently the deepening nightmare that is Syria and Libya, where the prohibition of torture is not recognized and where impunity appears absolute. I hope, therefore, that the Foreign Office of the United Kingdom will exert constructive influence over several states that have blemished records on torture and ill treatment. A state that is overlooked because it has no geopolitical value is the Gambia. During my joint visit with the Special Rapporteur on Summary Executions in November of 2014, we found the practice of torture was prevalent and routine, in particular by the National Intelligence Agency during the initial stages of detention. The government of the Gambia should not be allowed to get away with violating the terms of reference of our mission when we were already in the country. Bahrain requires careful monitoring. My planned visit to the country was twice cancelled unilaterally by the government, and it has now effectively shut down any engagement with my mandate. I continue to receive allegations of torture and ill treatment. The recent report of the Office of the High Commissioner investigation on Sri Lanka documented horrific levels of violations and abuses, including extrajudicial killings, enforced disappearances, torture, and systematic sexual and gender-based violence at the end of the armed conflict with the Tamil Tigers, and found that the state had failed to comply with its international obligations. The High Commissioner's call for the formation of a mixed special court in order to address the grave human rights violations and institutionalized impunity must be supported. The United Kingdom has, to its credit, affirmed the importance of involvement of the Commonwealth and other foreign judges, defense lawyers, and authorized prosecutors and investigators in this effort. I welcome the recent visit by the Special Rapporteur on Truth, Justice, Reparations, and Measures to Avoid Repetition, as well as the upcoming visit to Sri Lanka by the Working Group on Enforced Disappearances that will happen in November. I hope the government of Sri Lanka will consider inviting me for an official visit to help lay the groundwork to establish an environment to support transition towards accountability and justice. Saudi Arabia must be encouraged to review its practices with respect to the death penalty and corporal punishment, and to face its obligations to cooperate with the United Nations Special Procedures now that it has succeeded in getting elected to the presidency of the Human Rights Council. In my first report to the Human Rights Council as Special Rapporteur, I outlined the importance of applying a victim-centered framework to my mandate. I welcome the term survivor approach, which acknowledges those who have been tortured and resisted and have the strength to share their experiences. Survivors of torture should have a role in determining an integrated, individualized, and long-term approach to ensure adequate redress and reparation, including compensation, rehabilitation for themselves and their families, to afford their reintegration into the community or integration into a new society if they cannot return. In General Comment number 3, the Committee Against Torture interpreted Article 14 of the Convention, and it contributed to the evolution of the right to redress. The General Comment defines the scope of Article 14 to include as full rehabilitation as possible. It demands a comprehensive approach to redress for victims of torture and cruel, inhuman, and degrading treatment. It also reminds states of the obligation to ensure that rehabilitation procedures are gender sensitive, avoid re-victimization, and apply equally to all, including marginalized and vulnerable persons. A survivor-centered approach must include survivor participation in investigations, truth-seeking, and prosecutions as an important measure of the due diligence standard that applies to the good faith discharge of human rights obligations by states. It is important that survivors be entitled to initiate and to participate actively in such procedures of accountability. Access to rehabilitation programs should not be dependent on the victim's pursuit of judicial remedies. It is a state's obligation to provide redress by first conducting ex officio the necessary investigation and prosecution, but also by putting into place all the legislative, judicial, and administrative measures and institutions that will ensure access to remedies, reparations, and rehabilitation, and remove all obstacles to that access, legal or otherwise. Long-term rehabilitation measures, which are often provided by special torture rehabilitation centers, are cost-intensive, and those costs should ideally be borne by the individual perpetrators, their superiors, and the authorities responsible for the human rights violations. In my experience, states usually fail to institutionalize basic principles regarding redress to victims, as this is one of the areas where states often lack the political will. To prevent backsliding on torture, the coordinated efforts of various actors is required. At the national level, judges, lawyers, and prosecutors must play a critical role in the prevention of torture, including with respect to arbitrary detention, due process safeguards, and fair trial standards, and in bringing torturers to justice. Medical rehabilitation centers are key actors to inform, train, and mobilize doctors, lawyers, journalists, and other professionals in order to support victims and disseminate information about cases of torture, and to initiate programs of survivor activism. These centers are at the forefront of trying to stop regressive measures on torture and can play an important role in identifying strategies and reforms to address the systemic failures which breed impunity. These centers must be supported because an overwhelming majority of torture survivors do not have any other access to adequate treatment. I stress the need to contribute to the strengthening and cooperation of all mechanisms of supranational monitoring, especially those like the European Court of Human Rights and other regional bodies that issue binding decisions. Attempts at retreating from institutions like the Inter-American Court of Human Rights and the United Nations Human Rights Committee, as in the cases of Jamaica, Trinidad and Tobago, Peru, and most recently Venezuela, have always resulted and have been linked to reducing protections for victims of abuse. Implementation at an international level is also critical. Mechanisms such as periodic state-party reviews of the Committee Against Torture and the Universal Periodic Review by the Human Rights Council must be effectively used to urge states to report on steps undertaken to realize redress for victims of torture and to ensure follow-up on recommendations made by those bodies. In conclusion, if states effectively implemented national preventive measures and took affirmative steps to enforce their obligations, torture could be eradicated in today's world. Through standard setting, an important normative framework on torture has been achieved at the international and regional levels. The burden now rests on national governments to acknowledge, embrace, and implement the legal norms they have obligated themselves to uphold. Backsliding in the commitment to eradicate torture is not an option. Measures that permit torture or tend to make a state complicit in failing to stop torture by other states must be challenged. Every effort must be made to prevent further erosion of fundamental human rights principles. I reiterate my strong conviction that the abolition of torture in law and practice is a goal that we can and must achieve. It is essential to regain a universal moral condemnation that we had before 9/11 of 2001, and counter fallacious arguments about its inevitability or necessity as well as the argument that it works. Torture diminishes the worth and dignity of victims, but it also diminishes the worth and dignity of our own institutions and of our entire societies. It is up to us to recognize the essential moral imperative to prohibit torture and to fight against its use and for accountability everywhere. Again, I want to thank Freedom from Torture for giving me this opportunity to address the importance of not backsliding on the torture ban. I know that you are about to conduct a very gallant and important fight to preserve the protections that the United Kingdom has always given to torture victims everywhere. And in that endeavor, please count on whatever help the Special Rapporteurship on Torture can give you. Thank you very much.